Honorable Chief Justice of the Sikkim High Court, Shri Vishwanath Shamadar, please. Distinguished members of the Sikkim Judicial Academy, judges of the High Court of Sikkim, distinguished dignitaries present here, my friends in the bar, both junior and senior lawyers. I want to clarify before I start talking about the subject matter on which I'm going to address you that what I say here today is not in my capacity as President of the Supreme Court Bar Association, lest I may be understood, but as a citizen of this country, concerned about the trajectory that this country is moving forward in the ultimate goal of ensuring that democracy prevails in this country and that people at the bottom of the pyramid have access to justice. I've always believed that the Ministry of Law and Justice is a misnomer, because law and justice are distant neighbors, sometimes very strange bedfellows, and on many occasions highly suspicious of each other. Law does not necessarily mean justice, and justice many a times is far removed from the law. But we're going to discuss in the first part of this talk on the subordinate judiciary. We call it subordinate judiciary, and that too is a misnomer. If you look at the Constitution of India under the chapter subordinate courts, subordinate courts is being confused with subordinate judiciary. They are subordinate courts in the context of the administrative structure under the Constitution, but no court is subordinate to any other, especially the subordinate courts functioning through magistrates, through members of the subordinate judiciary, so-called, and district judges. And if you look at the history of India, you will find that a lot of this has evolved through a process which started way back in the Simon Commission of 1930. In 1930, the Simon Commission said that we want judges to be competent, to be independent, to be fair, and to be just. But that can only happen if the people of the country have confidence in the judiciary. In other words, the test of an independent institution is the constitution of is the confidence of the layman in the functioning of the system. You may call yourself independent. You may call yourself fair-minded. You may call yourself in every way trying to administer justice, but the fact of the matter is, if the people on the street don't have confidence in you, then you're obviously not independent. So, as I said, the Simon Commission set this out. And in 1934, there was a joint select committee. I am purposely taking you back to history because it will give you a flavor of where we are today. Way back in 1934, a joint select committee was set up for reforming the Indian Constitution. And this is what it said. It said this subject is not mentioned in the white paper, but there are aspects of it which seem to us of such importance that we think it is right to state our opinion upon them. The federal and the high court judges will be appointed by the Crown, and their independence is secure. I mean, that's the white man's opinion of itself, that as long as they are appointed by the Crown, their independence is secure, which was really not the case. But appointments to the subordinate judiciary, and this is again a wrong expression, appointments to the subordinate judiciary must necessarily be made by authorities in India, who will also exercise a certain measure of control over the judges after appointment, especially in the matter of promotion and posting. We have been greatly impressed by the mischiefs which have resulted elsewhere from a system under which promotion from grade to grade in a judicial hierarchy is in the hands of a minister, exposed to pressure from members of a popularly elected legislature. Nothing is more likely to sap the independence of a magistrate than the knowledge that his career depends upon the favor of a minister. It is the subordinate judiciary in India who are brought most closely into contact with the people. And it is no less important, perhaps indeed even more important, that their independence should be placed beyond question in the case of superior judges. Prescient words, true even today, and I'll tell you that in the latter part of my talk. Then came the 1935 Act, and Section 254 of the 1935 Act, it's very interesting, said, appointments of persons to be and the posting and promotion of district judges in any province shall be made by the governor of the province, exercising his individual judgment. And the High Court shall be consulted before a recommendation as to the making of any such appointment is submitted to the governor. A person not already in the service of his majesty shall be eligible, so forget about that. So therefore, it was the provincial government that was to appoint judges, subordinate, so-called subordinate courts, and the governor would do that. He may consult the judiciary in that regard. So as in 1948, when there was a conference of judges in which it was decided that, and this is very interesting and I quote, it said, so long as the subordinate judiciary, including the district judges, have to depend on the provincial executive for their appointment, posting, promotion and leave, they cannot remain entirely free from the influence of members of the party in power and cannot be expected to act impartially and independently in the discharge of their duties. It is therefore recommended that provision be made placing exclusively in the hands of the High Courts the power of appointment and dismissal, posting, promotion, grant of leave in respect of the entire subordinate judiciary, including the district judiciary. And in the Constituent Assembly debates, and I'm going through the history because there is something that I need to say of what is happening presently. When the Constituent Assembly debates took place, then there was the draft article of 209, Dr. Ambedkar said in a reply to the debate that the object to place the whole of the civil judiciary under the control is to ensure that judicial independence is within the High Court. That is the appointment process, the promotion process, leave, disciplinary action is vested in the High Court instead of in the provincial governments. That's how the change took place, and Article 235 was brought into the Constitution. So I gave you the history in order to just to tell you that at that time, of course, when the British were present, the judges on the criminal side were appointed directly by the governor without consultation with the judges of the court. On the civil side, they would have consultations. Why? Because when the national agitations were going on and sedition and other laws were imposed at that point in time, naturally, the then government, that is the British government, wanted to make sure that they have their own judges in place who could award any kind of punishment they wanted to. But that was, of course, all taken away when Article 235 was incorporated in the Constitution. And therefore this power was moved from the provincial government, that is from the states, to the high courts. And now the high courts have the power to take disciplinary action on issues of promotion, on issues of leave, and all that. The question still arises, and that's the question that we're going to discuss today. Are members of the subordinate so-called courts independent of influence? That's the key question that we have to answer today. The problem is the following. As we all know, the High Court is not subordinate to the Supreme Court of India. Entry 67 of List 2 says that the justice system is vested in the High Court. Except for jurisdiction of the Supreme Court, the jurisdiction of the High Court is independent of that of the Supreme Court. That's entry 67 of List 2. Entry 65 of List 2. Entry 77 of List 1 says that the Supreme Court's jurisdiction is all over the country. In other words, they will decide on their own jurisdiction. But they can't impinge on the jurisdiction of the High Courts. That's the constitutional structure as it prevails. But the heart of the problem, and I state so with a sense of responsibility, is the following. When the Judicial Committee in 1934 said that you should have the judges away from the influence of those who appoint you, now the very basis on which they wanted to move the power of control from the provincial government to the high courts was to ensure that there is no pressure from the government on the functioning of subordinate courts. But the same problem arises today, because the same power is exercised, instead of by the state, is exercised by the High Court. In other words, as you know, and most of you, those of you who are in the subordinate judiciary who have been around, know that there are judges who inspect, judges who come to get to know what your performance is, how you're performing, how many cases have you decided, how many trials have been going on, how quick you are in the disposal of cases, your leave, your promotion, all depends ultimately on the inspecting judge. And he decides what your performance is like. And as you know that within the judiciary, within the subordinate judiciary, there are 3 areas from which recruitment takes place to district judges. You have 65% of those recruited are done by promotion. 10% through an examination that is conducted. That makes it 75%. And 25% who are directly appointed as district judges. That's the structure. That's the structure of the subordinate judiciary today. That there are different modes of recruitment within the subordinate courts. Now what happens in the process is that the High Court is in complete control of the subordinate courts. And individual judges have their own equations with judges in the subordinate judiciary. And therefore, as you know, there are lots of disputes that arise on account of seniority. There are lots of disputes that arise because of the fact that some judge should be promoted, some judge should not be promoted. And even though the High Court is in complete control, the fact of the matter is that Chief Justices of the High Court are also appointed through the collegium system, in which the government also has a role to play. So the result is that there is a lot of dissatisfaction within the court system in India, especially in the subordinate judiciary. And I, as a lawyer, have come across so many cases. People come to me, sir, that I've been very, I've been not dealt with fairly. This judge is against me, that judge is against me. And that's not good for the system. But we've all borrowed it from the 1935 Act. Actually, the whole structure of the judiciary is borrowed from the 1935 Act. In fact, the structure of the Constitution is borrowed from the 1935 Act. We haven't had an innovative way of dealing with these issues. In fact, there has been way back, I think, in the Sital Bad, who was the chairman of the then Law Commission, made a recommendation that our district judges, we should have a judicial service where the recruitment to district judges should be on an all-India basis. That was recommended by Setal Wad when he was chairman of the Law Commission, and that recommendation actually has been reiterated by later law commissions. According to me, that would be an absolute disaster. Because if you have a judicial service for district judges, ultimately, who are going to appoint them? Who are going to post them? Who is going to which judge will go where? Ultimately is decided by whom? Can't be decided by the government, it will be decided through the collegium system. Does the collegium system have the wherewithal, have the machinery to be able to decide as to this particular judge will be appointed in this court and this particular district judge will be appointed in this court? What will be the constitution? Will we have a cadre system like in the IAS where just district judges will be assigned cadres? How will that be decided? These are very complicated issues. And I think a lot of the judicial reform that's taking place in this country is without reference to what the ground reality is. And the ground reality we all know is the fact that within the subordinate judiciary there is very little space left for the subordinate judge, for the magistrate, for the additional district judge, for the district judge, to take decisions. And much of it is because of the fact that he's afraid, because now with the collegium system, he doesn't look to the politician, he looks to the judge in the High Court. That's the reality of India. So he looks to a particular judge in the High Court and he wants to make sure that the decision that he takes does not make the judge who is going to ultimately decide where he is going to go and on his promotions, that he is not unhappy. So the entire subordination process actually in his decision making is subject to the whims and fancies of judges who are sitting in the High Court. This is a problem, it's a real problem. The judges are more concerned about their future. Will they be promoted? Will they be picked up? Who will pick them up? Who do I go? Who do I go to? These are very, very complicated issues. And we've not been able to resolve it. Why do you think that in this country, even though the law is, bail is the rule and denial is the exception? How many subordinate courts give bail to people? And why do they not give bail to people? That's the heart of the problem. Because they are worried that if they give bail, then somebody will say, this was motivated, so it's better not to give bail. We must ask the question, why are they worried that if they don't grant bail, they may not get their promotion, or they may be transferred? If judges of the High Court can be transferred, if they give decisions in a particular way, Justice Muralidhar is an example, Justice Qureshi is an example, then why is the subordinate court or the subordinate judge not afraid of his posting and his transfer? As long as you have a center of power vested in a particular institution which controls the subordinate courts, you will not get the independence that we're talking about. We need to move away from the centralized system of control. You can't have the High Court on its own controlling everything in the subordinate judiciary. Just as you can't have the collegium system deciding who should be appointed into the Supreme Court, who should come to the Supreme Court, who should not come to the Supreme Court. That's really the heart of the problem. Because concentration of power always leads to arbitrariness. The same thing as far as the Supreme Court is concerned. How does the Supreme Court exercise control over the high courts? Not that the Constitution allows it. It doesn't. But the collegium system allows it. Previously, and I know that for a fact because I've lived through both those regimes. In fact, I and Fali Nariman were the ones who argued the case on Advocates on Record Association, the 1993 judgment, which moved the power to appoint away from the executive to a collegium within the judiciary. And the problem was that at that point in time we thought that lawyers and judges were running to politicians for their appointment. They would pay obeisance to the powers that be. So instead of doing that, let's have a collegium system, because judges of the Supreme Court and of the high courts best know which lawyer deserves to be elevated to the bench. That was the thought behind it, and it was a good thought. It's not something that was inimical in the context of our constitutional structure. So we thought at that point in time that judges, because they are the best in terms of who should be appointed, will decide on a fair basis as to who should come to the Supreme Court and who should not come to the Supreme Court. But the problem arose thereafter, because instead of lawyers running to the politician, now lawyers run to the judges. Your high court judges go to judges of the Supreme Court and request that they be considered for appointment. And when Chief Justices are appointed around the country, which Chief Justice will go to the Supreme Court depends on what? What are those parameters? Nobody knows what those parameters are. I mean, naturally, this is human frailty, that if I am a Chief Justice of, say, in Maharashtra, or I am Chief Justice in Tamil Nadu, I am Chief Justice in West Bengal, then I will carry a good opinion about X, Y, or Z judge. So when I go to the Supreme Court, naturally, I would say he's a good judge, you bring him in. And some other Chief Justice, some other High Court will also have recognized some good judges. He will say, why don't we bring him in? And then some other Chief Justice will have the same view about his judges when he was in the High Court and he's in the Chief Justice when he comes to the Supreme Court. And because there is consultation with the government in power, the government will say, fine, I appreciate what you're saying, you resolve amongst yourselves as to who you want, but I too want some, not one or two people. This is what happens in reality. And we must be open about it. I mean, we can't change the system unless we talk honestly about the system. There's no point in sort of pushing this under the carpet. The collegium system is a system through which appointments are made not on merit. Not necessarily on merit. I can't possibly say not on merit. Not necessarily on merit. And that's where the problem arises. The Chief Justice looks up to the Supreme Court judges. And that's reflected in their orders. I'm sorry to say that. That's reflected in their orders. Highly liberal judges who become Chief Justices suddenly find, at least I find, that the color of their judgments is very, very subtly being changed. Because it's human frailty. You want to go to the Supreme Court. There's nothing wrong with that. So the High Court judges become subordinate to the Supreme Court. The constitutional structure doesn't allow it. But that's the reality. The High Court judges look to the Supreme Court for moving up the ladder. The subordinate courts and judges of the judiciary there look up to the High Court to go to the High Court. So the 1934 Judicial Committee said judges should be competent, judges should be fair-minded, judges should be independent, but the test of independence is the confidence of the public in the judicial system. And one very distinguished judge, sitting judge of the Supreme Court, said very recently that if people lose confidence in the judicial system, then vigilantism will prevail. That's what's happening. You have highly controversial matters coming up in Supreme Court. And this is only one part of the problem. The other part of the problem is even more serious, which is the concept of the master of the roster. It's even more serious than what I have presented to you. Because the master of the roster will decide which matter will go to which bench. And then the problem is that an attempt is made to ensure that a particular judge becomes the Chief Justice of a particular High Court. And then that Chief Justice of that High Court decides on the roster. I don't want to say anything beyond that. So these are highly serious institutional issues which are required to be addressed afresh. We can't move ahead with the same system in place if we really want an independent judicial system. We need to move away from centers of power, wherever they may be, and move from that center of power to an institutional system which reflects the opinion of a broad range of stakeholders with checks and balances to ensure that how the system will move forward. So neither the original power structure in terms of which the executive appointed judges, nor the prevalent power structure by which the collegium appoints judges has served the cause of independence of the judiciary. We need to look at all this afresh. We need to make sure that we have a system in which appointments, promotions, disciplinary actions are vested in an authority where all stakeholders are represented, which includes men versed in the law, eminent persons within the community, retired judges, and of course representatives of the government or who have been in the government. But they must be not serving people within the system, because they are serving people within the system, you'll have a stake in the system. Now this is very complicated. I mean, in the UK, for example, they've moved away from the whole judicial commission through which appointments take place, which are represented in all stakeholders within the system are represented in that judicial commission. And they are the ones who make the appointment. So we need to do that, but nobody is talking about it because it serves the system. I mean, there is an inbuilt pressure to continue with the status quo. That's always the case. To change the status quo is perhaps one of the most difficult things. I mean, whether it's political status quo or status quo in any institution, to change it is very, very difficult. And therefore, what I'm saying today are presenting you with the problems. I don't have a clear solution to it, quite frankly. But at least the problem should be addressed. The solutions will emerge only if the problem is addressed. At this point in time, we're not even addressing the problem. And therefore, it's important for us to do so. And therefore, the judge who deals with the case should have the confidence that in whatever manner he deals with that case, whether he be the judge of the High Court or judge of the subordinate courts, he will not be held to account. for his decision. We know recently of a lady judge in the special court granting a particular order to a particular eminent personality within the political system, and immediately the judge was changed. Right? Now, this sends the signal that if the judge is going to be changed, if you give this kind of decision, you will also be transferred. No judge wants that. No judge wants that. And therefore lobbying goes on within the high courts. Lobbying goes on within the Supreme Court as to who should be appointed, who should not be appointed. And this doesn't augur well for the independence of the institution. And what is independence? Ultimately, what is independence? Independence is that we two people on the other side of the aisle, across the judge, when we come out of court, we feel the judge is going to decide in accordance with law. We have confidence in the system. That's what independence is. That the litigant feels confident about the institution. Not that the judge feels confident about his own independence. That's the test. And I dare say, go and ask the public of this country. Look at what's happening. I mean, I think it's the most unfortunate thing that in the social media platforms, the kind of things that are being said about our judiciary. It pains me. What does it reflect? That people have started attributing motives. And if the people of the country start attributing motives for judgments, that's the saddest day as far as the institution is concerned. And the institution has to worry about it. I mean, I have been now in the Supreme Court for 50 years. 50 long years. I've seen the 5 courts working at a time when there were only 5 courts in the Supreme Court. I have practiced before the father of the present Chief Justice of the Supreme Court of India. I have practiced before Justice A.N. Reid when he was Chief Justice, before Justice Matthew, before the great stalwarts of this country. But now the nature of litigation has changed. Which court will be heard first? That problem never arose because the plethora of litigation was not there. I mean, today there is a tsunami of litigation. God alone knows who is going to, which matter is going to be heard first. And nowadays, in fact, in Supreme Court, we get to know in the morning which case is going to be heard. Or maybe at 12 o'clock at night. So these are very serious issues which I'm sorry to say no bar association addresses. Judges don't address. And in fact, we have statements from the political class that there should be collaboration between the bench and the government, in the sense that we ultimately are working for India being Viksit Bharat, as it should be. And therefore we must work together. But as I said, that law and justice are strange bedfellows and should be suspicious of each other. A law that is, and I'm going to talk about that in the next session, a law that is framed doesn't mean that it is just. And a judgment that is rendered doesn't mean that it is the law. We've seen that happen all the time. I'll give you a small story which is a personal anecdote and I'll end this session. I was a young lawyer, 24 years old, and a client came to me from a constituency called Mehem from Haryana, young 25-year-old. person who had won the election. And his election was set aside in the High Court of Haryana on 8 counts. So he came to me and he said, "Sir, I've seen you argue somewhere and I don't have any money, but I want you to argue my case." I said, I was a briefless lawyer, so I welcomed him. I said, "I don't need money, I'll do your case." And it ran into thousands of pages. And it was an election appeal before the Supreme Court, and I thought as a young man, considering Section 116A of the Representation of People's Act, that there's a right of appeal. So the bench that it was listed before was presided over by Justice Palekar. We had Justice Palekar, Justice Bhagwati, and Justice Sarkaria on the bench. And it was Justice Palekar's last, the last case that he was doing, the regular case that he was doing. So I got up and said, "My lord, there's a right of appeal and please admit the matter and hear it." And Justice Palekar said, "Young man, you know nothing about the law of this court. Merely because it's an appeal doesn't mean that we have to hear you. You have to prima facie tell us what's wrong with the judgment." So I said, "Okay," because I had only one brief, so I worked on it for months. So I told the judge, "Okay, you set aside your brief and I tell you what the case is." And I spoke about half an hour. I addressed them. And Palekar said, "Young man, we'll hear your appeal." Okay, and I started arguing. At which point, Justice Bhagwati told me, and I tell you what the point was. The point was that my candidate, on facts, has given money between the date of nomination and the date of withdrawal to another candidate to withdraw his candidature. Right? And that was bribe under 123A of the Representation of People's Act. So Justice Bhagwati said, "Young man," and this was sometimes in July, he said, "Young man, in May I have just rendered a judgment in another case where the same thing happened, and it is bribe within the meaning of 123, and therefore what's the point of hearing your appeal? It's covered by my judgment. What do you have to say?" So I said, "My lord, your judgment is wrong. I'm sorry." He said, "How do you say that, young man?" So I argued. The matter went on for 19 days. I was opposed by the Advocate General of Haryana at that time who took a private brief. When the judgment came, I lost. But I had succeeded on 7 counts. I lost on 1 count, and Justice Bhagwati reviewed his judgment and said that I was wrong. Because I said that when a person files his nomination till the date of withdrawal, he is not a candidate. And if he is not a candidate, he is not covered by 123A. He accepted that, wrote a separate judgment. You don't have judges like that anymore. But the interesting part is the next. So I felt very, very sad that this man, I had succeeded on 7 counts, I lost on 1. So years later, Justice Sarkaria, who had retired from the bench, on an evening, in a festive occasion, took hold of my hand and said, "Kapil," by that time they called me by my first name, "I'm very sorry that you lost your case." And he remembered it. I said, "Sir, why are you sorry?" He said, "I and Bhagwati wanted to decide in your favor, but it was Justice Palekar's last judgment. And he didn't want to decide in your favor. And we didn't want to differ with him. But we were wrong." The point is, the same thing happened when I met Justice Bhagwati and he took me aside, he said the same thing. What I'm telling you is, law sometimes, justice sometimes does not mean that it's in accordance with law. It's the 1934 Judicial Committee. Law and justice, don't confuse the two. Laws are unjust. Sometimes justice too is unjust. Thank you very much. Thank you very much. Great to be back here again. Though the two topics are in a sense removed from each other, but there's a commonality between the two topics. Today, in this particular talk, I'm going to talk about precedent, the value of precedent in the Indian legal system. Now, essentially, precedent is something, stare decisis, precedent is something that evolved within the common law system. And because in England there is no constitution, and therefore judicial principles had to be decided on the basis of authoritative pronouncements of judges. And the principles on which those pronouncements were made became precedents as future judges tried to apply that principle or applied that principle in their future pronouncements. But the fact of the matter is that we've moved away from the common law system, and we're now covered by the concept of statutory laws. In other words, statutory laws actually don't give you the kind of space that's available within the common law system to decide cases, because the statute really governs the process of decision making. There are some statutes which do not allow any space at all. So therefore, in a sense, there has been a movement from the common law to statutory law-based rights. And the basis of stare decisis was that there should be an element of stability, an element of predictability in the context of precedents. You have a precedent and you follow that precedent, then lower courts know that, look, this is the precedent, there's an element of predictability. There is very little flexibility in that regard. And this really happened when the federal court and the Privy Council judgments were applicable in respect of disputes in India. And Privy Council judgments were binding. And many Privy Council judgments and federal court judgments were based on precedents. And they became precedents within our system. And then came the utilitarian movement in the UK with Bentham saying that, you know, we must have legal rights in the context, of course, of commerce and other things. And therefore we must enact laws in terms of which the behavior of parties will be regulated, and therefore became the genesis of common law. And at that point in time, Macaulay then decided to draft the Indian Penal Code. And that's how the Penal Code came to be adopted by us. And then, of course, the Evidence Act was drafted by James Stephen. And so those became the statutory modalities through which the court system functioned in our country for many, many years. But the age of statutes has overtaken the common law system and overtaken the concept of, in a sense, stability and predictability. Now, I don't mean it in a derogatory sense, but there is very little stability and very little predictability in our system today. Because we don't know what the judge is going to do. We don't know what the judge is going to follow. You have the Indira Sani case, we talked about 50% cap. Where is the 50% cap today? There's no 50% cap. You have the amendment to the Constitution, which says that now 10% will be given to the economically weaker sections of society. The 10% is over and above the 50%. And then you have states which have already reserved 69%, beyond the 10% that we're talking about. So there is a state which has 79% reservation. So where's the predictability? And where's the stability of our legal system? So that's something that is a matter of great concern also. Therefore, precedent has very little value within a statutory-based system. And the law declared by the Supreme Court is binding on everybody. But then what's the Supreme Court today? The Supreme Court doesn't sit as one court. It sits in benches. Every judgment of the Supreme Court is a judgment of the Supreme Court, of all the members of the Supreme Court. And one judgment says one thing, the other judgment says quite the opposite. So who are you to follow? Which judgment are you to follow? So there is an element of lack of predictability and lack of stability within our system. But that's one very major problem that we are faced with within our judicial system. Now, in that context, let's sort of analyze some of these things. Take, for example, the PMLA, because instead of giving you an academic lecture on precedent, let's talk of reality. Let's talk of the PMLA, and let's talk of precedent in the context of PMLA. Now, as you know, Article 21 of the Constitution, it says that no person shall be deprived of his life and liberty except in accordance with procedure established by law. That's what 21 says. Now, what's the procedure established by law? Is the PMLA a procedure established by law? PMLA is the law. And if you remember in Maneka Gandhi, what Justice Bhagwati said, the procedure must be reasonable and the substantive law must be reasonable. So reasonableness must be an underlying theme in the respect of procedures within the criminal justice system as well as the substantive law. Now let's just test the PMLA. Now you have a section 45 in the PMLA which says that anybody being prosecuted under the PMLA, when his application for bail is moved before the court, magistrate's court or whichever court, then notice has to be given to the public prosecutor. And unless the court comes to the conclusion that the person is not guilty of the offense, he can't be granted bail. Now, just look at the scenario. I am an accused, I get arrested. When I get arrested, it is pursuant to what is called an ECIR, which is registered by the enforcement authorities. It's called an ECIR. ECIR, unlike an FIR, is not in the public domain, so I don't know why I was arrested. Right? So I get arrested, I get produced before the magistrate. Now, I don't know what the allegation against me is. I go to the magistrate. A remand application is filed by the public prosecutor, which he hands over to the judge. I have no access to the remand application. So I don't know the case against me. And the section 45 says that unless I am able to show that I am not guilty of the offense, I can't be granted bail. So where is the procedure to show that I am not guilty of the offense? I don't know the accusation. I don't have the remand. I'll have the remand at that point in time. I can't have a discussion with the lawyer. I'm not given the grounds of arrest. Nothing. Now, Article 21 says that the procedure established by law should be reasonable. Is this a reasonable procedure? Obviously not. Now the Supreme Court has upheld it. Now if the Supreme Court has upheld this procedure, is that a precedent? Yes. Precedent in what context? In the context of the letter of the law. So the letter of the law can't be a precedent. The letter of the law tells you that you shall not get bail unless you satisfy that you are not guilty of the offense. And incidentally, it's very interesting that in the PMLA, section 19 of the Act says the authorities can arrest you after the authorities have material in their possession that you are guilty of the offense. See the chasm between the two. The authority that arrests me must have material in its possession that I am guilty of the offense, and then only they will arrest me. But the material in his possession that I am guilty of the offence is not given to me. That material is sent in a sealed cover to the magistrate. That's the law. That's why in the first part of the lecture I said that there is a chasm between these are strange bedfellows, law and justice. This is nothing to do with justice. It is something to do with the law, and the law is the precedent. If you uphold the law, it becomes the precedent. Right? The magistrate has no space to differ. He cannot exercise his judicial judgment. He can't exercise it because the accused does not know what is against him. Right? That's on procedure. The other thing about procedure, I give you this example so that you understand where our society is moving, where our laws are moving. Now, as you know that under the Code of Criminal Procedure, which the Supreme Court has held in various judgments, is the procedure established by law? In other words, you have an FIR. After FIR, within 24 hours, you have to be produced, which applies to PMLA also, before the magistrate. Remand is taken. I have the FIR, I have given access to the FIR. Now, of course, it's in the public domain because of pronouncements of the Supreme Court. So I get a copy of the FIR. Then there are procedures which say that every 14 days after remand I have to be produced, fine. Thereafter, there is a daily diary. Under the Code of Criminal Procedure, in the daily diary, whatever the investigating authorities does has to be put in the daily diary, has to be recorded in the daily diary, which witness he has examined under 161 is recorded in the daily diary. The progress is all in the daily diary. And then after the investigation is over, thereafter a final report is submitted. Right? Either it will be a closure report or a final report on the basis of which the judge will take cognizance and ask me and send notice to the accused. That's the procedure that's absent in PMLA. There is no daily diary in PMLA. What the investigating agency is doing, nobody knows. What time he examined whom, nobody knows. Which document he takes on record, nobody knows. Nobody knows. There is no procedure. And the Supreme Court says in Vijay Madanlal Chaudhary, this is procedure. Upholding the PMLA. We've been crying hoarse month after month. After the Supreme Court has said that this matter should be reviewed, this judgment should be removed, month after month, we've been requesting the Supreme Court put up the matter for disposal. 2 years have passed. Now, of course, it is now listed on 27th and 28th of November of this month, and I'm going to open the argument on that. I'm just telling you, when you're talking about precedent, there is no concept of precedent in today's judicial processes. And what about this is about procedure, but what about the substantive law? That's even more interesting. Under the PMLA, I'll assume now that I have committed a crime. Crime which is set out in the schedule to the PMLA. Supposing I've cheated somebody, 420 is part of the schedule of the PMLA. So I've cheated somebody of, say, 1 crore. Right? Matter of cheating. Now, if it were under the penal code, PMLA will not apply. Supposing, because the investigating officer can proceed against me for cheating under the PMLA, he can also proceed against me under the IPC. So if he proceeds against me under the IPC, their twin conditions need not be satisfied under section 45. But if he proceeds against me under PMLA, the twin conditions have to be satisfied. So he has the discretion to proceed against me either under the IPC or under the PMLA. What does it lead to? I don't have to tell you that, what it leads to. You give that kind of discretion to the investigating authority, what it leads to, everybody knows. then these are proceeds of crime, and I gave you an example of 1 crore are proceeds of crime. Then what happens? Then there is an offense. Proceeds of crime is a crime under what is called, quote unquote, a predicate offense. That is the offense under the schedule, right? But there is a separate offense which is called money laundering. Now, what is money laundering? I'll give you a small example. Most of the housewives here would know, will be happy to hear this example. You have dirty clothes, right? Every morning or every night you put it in the washing machine and it comes out clean. So you've laundered the clothes. Now, if you have dirty money and you put it in the legal system, in other words, you get cash of 1 crore, you buy an entry, and you say that you bought gold from that. So you have tried to legitimize dirty money into clean money. So you have laundered. Right? That's what's called money laundering. Now, the judgment says that there is no difference between proceeds of crime and money laundering. The judgment says it, though it's a separate offense. What do we do? So every individual can be proceeded against money laundering when there is nothing to show that he's ever laundered money. Supposing I've committed a crime for 10,000 rupees or 1 crore rupees, and I keep that 1 crore in my house. I've done nothing about it. I'm the person who has cheated, I've kept it in the house. I've not laundered it, but I'll still be prosecuted for money laundering. How do you justify that? So the law is substantively unreasonable. The law is procedurally unreasonable. Procedurally unreasonable, and yet that's the law of the land, and that's the precedent. What's the principle that I'm trying to canvass before your lordships? The principle is that the greatest enemy of judicial precedent is the law, because it gives no space to the judges to act otherwise. Because a magistrate cannot say, no, I will not follow the twin test. He has to follow it. That's the law. And it's upheld by Supreme Court. So he has to reject bail. How can he grant bail? Okay. Now that's what it was till such time as some judges of the Supreme Court said, this is absurd. People are been incarcerated for months, for years, and they are still there, and no bail because the twin test is not satisfied. This is completely wrong. So, recent judgment in Pankaj Bansal said the following. It said, look, what is this going on? You arrest a person, you accuse him of money laundering, and he has no wherewithal to defend himself. None whatsoever. So therefore, I now declare the law. That, what is that law? That when a person gets arrested, he must be informed in writing of the grounds of arrest. Not in the law. It's not in PMLA. Not only must he be informed of the grounds of arrest, so that when he goes to the court, he is able to tell the judge that these grounds of arrest, I have nothing to do with them, I have not participated in any of these activities, and there's no evidence to show that at least I can argue my bail. Not only that, the court said this is also violative of 22. Article 22 of the Constitution. Now judges realize that this kind of unreasonable law, even though we cannot strike it down because it's been upheld, but we must find a way for the ordinary citizen to get relief. And the only way to get relief is to find some kind of exception which has a constitutional basis. And so the Supreme Court then, this started the process of releasing people on bail, Pankaj Bansal's judgment. This then was followed by other judgments. Then came another breakthrough. Court said there may be these twin conditions, but the fact of the matter is that the man has been there for 4 years. And the complaint stands filed against him already. The charge sheet stands filed. The complaint under PMLA stands filed. So in the predicate offence, the charge sheet is filed. In the complaint, in the PMLA offence, the complaint is filed. Why do you want to have him in custody? Now the constitutional basis for that, the court said, is because you have Article 21 of the Constitution which says that no person can be deprived of his life and liberty except in accordance with procedure established by law. And it is not fair to keep a man for 4 years inside bail when you don't need to investigate him any further. So therefore, keeping him in bail despite the twin conditions is violative of Article 21 of the Constitution. Right? That can't be done by the magistrate. Magistrate has no right to start interpreting the Constitution and say this is constitutionally valid or invalid. He has no such power. Only the High Court has such power. But as I told you in the earlier part of the talk, High Courts are reluctant to exercise that power. For reasons that we all know. So it comes to the Supreme Court, but it takes years for the Supreme Court to find ways to navigate through this fabric of injustice which is part of our legal structure today. And this is how we destroy freedoms in our country. You want to prosecute a man, you prosecute him, convict him. And these are all laws that we have borrowed from English statutes. For example, CRPC. Now, I have never understood, as you know, that once an FIR is filed, if it's a cognizable offence, and you all know this, lawyers know this, others who are in the police establishment know this, the moment there's a cognizable offence, you have to arrest the man as soon as the cognizable offence is committed. That's the law of the country, right? But you can arrest him on suspicion. Most of the arrests in this country are taken on suspicion. And this is again, it's something very, very strange, and I've been fighting against this. When the court says that if I make an allegation, the police officer must accept the allegation to be true. And if it discloses the commission of a cognizable offence, then I have to be arrested. Right? Now, if I make an allegation that this person has intention to kill me, and on such and such day he came to my house and threatened to kill me, therefore it's 506 of the Penal Code. And therefore I'll be arrested. Now, whether that is true or not, as long as the FIR discloses a cognizable offence, I have to arrest it. In the developed world, the allegation is first investigated, then an arrest takes place. In our world, the arrest comes first and the investigation comes later. That's what it is. That's the reality of India. You will get arrested and then you will be investigated. Then what will happen? You take him into custody and seek police remand. Which country in the world has police remand? No country. It's the colonial past which has given the police this power. That why will you take me into custody? In police remand means I will be kept under the custody of the police. Why? Why not in judicial custody? And what's the difference between the two? Custody is custody, no? Whether it is judicial or police. But the difference between the two is that you can threaten the person. When you're in police custody, I'll have your wife arrested. I'll have your relationships arrested. I will start prosecuting your son. Right? Unless you say this, unless you name this man. So guy will say, I want to protect my family, so he's named the man, and then you'll go to the court and say he's named that man, so I go and arrest him. And the court says, I have no basis of saying that this is wrong. Is this procedurally reasonable? The whole criminal justice system is a legacy of the colonial past. This whole criminal justice system needs to be revamped. And I just given you an example of the PMLA just to show to you the enormous injustice. Documents can be put in the file at any stage. And this is a grave threat to our democratic freedoms. And now you have new laws which are in fact far more stringent than the colonial laws as well. The new BNS, I don't want to sort of dilate on that. That's another issue. But now the point that I am making is there are no such thing as judicial precedents at all. Because it has been overtaken by statutory law which gives no space to the judiciary because of the stringent conditions of those laws. And then the other problem is that you have several Supreme Courts in the Supreme Court. Because judges sit in benches, they declare the law, and then any number of judgments of the Supreme Court, and each judgment is binding. So, even that judgment is not a precedent, because you will have another judgment saying quite another thing. Okay, now let's move away from that a little. Now what happens in the context of precedents? Take for example equality. As a constitutional principle. Can there ever be precedents in respect of equality as a concept? That my right to equality has been violated will depend on what? Not on a precedent. It will depend on facts. That I have been discriminated against, whether it's service law or it's any other law. It will all depend on facts. My right to free speech depends on facts. There can be no precedent. Public interest, what is public interest? Depends on facts and the women fancy of those who decide, based on law, hopefully. It depends on them. There can be no precedents in situations like this. You are interpreting constitutional provisions and fundamental rights of our Constitution, the right to free speech, the right not to be discriminated. And what is security of state? If people are agitating, students and agitating, are they threatening the security of the state? And you will arrest them under UAPA, and the UAPA doesn't have the same conditions for the grant of bail. So young students are inside for 3 years, 4 years, without hope for getting bail. Where are we going as a country? How do we move forward? Unless we rethink about our own system, our judicial system and the way it's functioning. And these laws are made what? By people like us sitting in Parliament with brute majorities. These are laws made by brute majorities. Law-making is a collaborative process. It's no longer a collaborative process. So I've talked of one part of it, namely the unfairness and unreasonableness of substantive laws and unfairness and unreasonableness of substantive procedures. But there is an even more disturbing fact, which is how laws are being destroyed and precedents are being created through the executive. This is very interesting. There's a law in place, and the executive has to implement that law, right? Now, the implementation of that law is as important as the substantive provisions of the law. Its implementation is as important. Now, what do you have? You have special judges being appointed for these courts under PMLA, right? You have special judges all over the country. Rao's Avenue in Delhi has a lot of these special judges. Now, who appoints these special judges? The High Court in consultation with the government. That all depends on who is at the helm of affairs in the High Court. So special judges are appointed. And the investigating agency then comes before that special judge. The investigating agency is entirely under the control of the government. PMLA is entirely under the control of the government. UAPA is entirely under the control of the government. So what do you do if an offence is taking place in West Bengal or an offence is taking place in Karnataka under the PMLA? Then what happens is that that person is arrested, but he is brought to Delhi before the special judge. Why? Because some little part of the transaction has happened in Delhi. In other words, in the PMLA matter, a small part of the money was deposited in a bank account in Delhi. So it gives jurisdiction to the investigating agency, namely the enforcement directorate, to bring the accused to Delhi, to have the trial in Delhi before the special judge in Delhi, even though everything has happened in West Bengal and has happened in Karnataka. So the executive plays an equally, a much worse role. And what's the space for the judiciary? None. So the law is oppressive, the agencies of the state are oppressive, and there is no space for the judge to protect the citizen because the law is such. And what's the hope? Our high courts and the Supreme Court, because those are the only constitutional courts which can declare these laws to be unconstitutional. But how many laws in the last 10 years have been declared to be unconstitutional? I dare say none. Very, very, very few. Not certainly in the context of liberty. So therefore you have the law which is oppressive, and you have then the executive acts, the agencies which are oppressive, and then you have judgments that are oppressive. Like the Vijay Madan Lal Chaudhary judgment. Tell you a little story about it. A lot of these provisions, and I'm just telling you how the role of the judiciary has been slowly diminished, and unless the judiciary rises to the occasion and asserts its independence, quote unquote independence, democratic freedoms are essentially very fragile today. So what happened was that, as you know, that under parliamentary procedures, a bill can be passed within the finance bill. A statute can be amended within the finance bill. And once it is passed in the finance bill, it cannot be voted upon in the Rajya Sabha. In other words, a law which is not in the finance bill will be voted both in the Lok Sabha and the Rajya Sabha. But if it's in the finance bill, it will only be voted in Lok Sabha and not in the Rajya Sabha. So many of these amendments in the PMLA were passed in the finance bill, so that they can't be voted upon in the Rajya Sabha because the government in power didn't have majority in the Rajya Sabha. Many of these amendments. So a question arose in the Supreme Court as to what do you mean by quote unquote a money bill. And 5 judges, and when a money bill is introduced, it is the Speaker who declares it to be a money bill. And if the Speaker of the House declares it to be a money bill, then it's binding. So the question arose whether the ruling of the Speaker is an impediment in the court's jurisdiction to interfere and decide whether or not a particular legislation which was amended and was part of the money bill, right, is in fact a money bill or not. Because an ordinary amendment to the PMLA has nothing to do with money because there is no appropriation involved. A money bill is what? When I go to Parliament and I say my budget is to be passed because appropriations have to take place, that's a money bill. When I say, okay, the Department of Child Development, the Department of Social Welfare, the Department of Telecom, the Department of Industries needs this kind of allocation for our expenditure in the plan, is a money bill. But an amendment to the PMLA is not a money bill because it doesn't require any appropriation. But the Speaker will declare it as a money bill. So it can't be discussed in the Rajya Sabha and voted upon. Now that question is pending before 9 judges because our present Chief Justice differed with the judgment and said you go no with it, but that matter is not listed. So oppressive laws not discussed in Rajya Sabha, nothing to do with the money bill, are not decided upon when the matter is pending in Supreme Court. So what's the space for the judiciary? We can't even challenge these amendments. So the oppressive laws are being implemented. What's precedent? There is no such thing as precedent. Each judge decides in the context of his or her understanding of the law whether he should interpret or she should interpret the law one way or the other. But where does the citizen go? These are serious issues. So I say to you that the only precedent is the precedent of the individual bench which decided a particular case in the way that it decides, is the only precedent. That's it. And who suffers? Ordinary people. So it's time for the judiciary to realize that it's time for them to stand up and to ensure that what our forefathers gave us need to be zealously protected. These are rights that they gave to the citizens of our country. They can't be wasted in this fashion. It's time for the citizens to speak up. It's time for the lawyers to speak up. And it's time for the judges to stand up. Thank you very much.
Thank you, Honourable Sir, for the enriching session. The topics covered in this session indeed makes one put on their thinking cap. With this, we have come to the end of the second session. The floor is now open for an interactive session of 20 minutes. I encourage everyone, especially the students, to make the best of this opportunity.
Very good afternoon, sir. Myself, I am Srijan Pradhan from Sikkim Government Law College. My question today is, what are your personal observation on judges getting appointments or benefits post-retirement? As we have seen recent trend, judges taking voluntary retirements and contesting elections. Do you think that this kind of trends will even slightly impact decisions, because judges are already eyeing for to impress the government, as in they will get good appointments after the retirement or taking voluntary retirements?
Young man, you know the answer.
What can be the possible solution for this? And my other half of the question is, like recently Supreme Court of India changed the emblem and flag and also converted the Judges Library to museum. And today only I came across the news that Supreme Court Bar Association objected it. And why did Supreme Court Bar Association object?
So I am at the moment, as I told you in the beginning of the lecture, speaking as a citizen, not as president. The moment I respond to this, I'll be attributed a motive.
Thank you so much.
Good afternoon, sir.
Yeah.
This is Zituraj Hall. I'm Assistant Professor of Law at Indian Institute of Legal Science.
So my question is with regard to the first session. So you opposed about the centralization of the power, or the primacy of the power that is captured by the judiciary in respect of the collegium system. So my question is, so what is your opinion with regard to the scheme that was proposed by the 99th Constitutional Amendment Act, that is NJAC? Do you think that the NJAC decentralizes the power, or if not, then what is the mechanism that you propose?
See, the problem is that the system, whatever system you want, whichever architecture you want to create, it must not be a cozy chamber between the government and the judges. It must involve other stakeholders. The NGAC that you are talking about ultimately involved what? Minister of Law, Chief Justice, and therefore this is happening informally even today. There's no difference. And we may say that all the appointments are at the collegium decide. That's not quite true. I mean, I have no personal knowledge of it, but from the scheme of things that I understand, that's not quite right. That's not quite true. So what you need is a representation of key stakeholders in the system, which involves people like us who are outside of the collegium, right? And they say, okay, government will nominate two eminent persons. Now, two eminent persons are the eminence is in the eyes of the beholder, no? Right? So he will decide who to appoint. So that's not how it can work. As I said, there is a judicial commission in the UK. Maybe that's not perfect. Maybe we must evolve our own architecture for doing this. But all stakeholders, people with unquestionable integrity. I mean, even if I were a practicing lawyer, I should not be there, because a practicing lawyer will also have some interest as to who should become a judge. So even I as a practicing lawyer should not be part of that system. But those who have no real immediate stake in the system require to be consulted. Now, how that happens, at least let's start a debate. I mean, I can't give you a perfect solution, but I can give you a better solution than the present one. Okay?
Hello, good afternoon, sir. I'm Advocate Qazi Sangeethuddin. First of all, I would like to welcome you on behalf of the bar.
Thank you.
I just have two questions. The first question is regarding the criminal law element that you were talking about. There's a very interesting question that me and my colleagues keep talking about. So if, sir, you've seen Article 115 and 116 of the Limitation Act. It gives you around 60 days to file an appeal to the High Court against a conviction. But at the same time, a civil case, you get 3 months. Now, knowing the nature and seriousness of what you're challenging in a criminal case, the volume of documents, shouldn't that be amended, number one? Number two, the Limitation Act itself has not amended even the wording such as Code of Criminal Procedure 1898. So I think that also needs to be amended, since you're
I agree.
a member of Parliament.
I agree.
So I think those things also need to be taken account. Secondly, the other question is, so you were absolutely right about human frailty regarding the collegium system. Because what is exactly happening is, now in the collegium system, a lot of judges call their colleagues to the Supreme Court. Now what thereafter happens is, states like ours, Sikkim, we are very...
Don't start telling the truth to the public.
All I'm saying is we are underrepresented in the courts. So I think that also needs to be taken into consideration, that smaller high courts also need to
See,
be
those who
represented.
pander to those in power, and I'm not talking about the judiciary alone,
Yes, sir.
those who pander to the power get all the fruits
Yes.
of power.
Yes, sir.
Right? So those who pander, don't pander, are left out. That's what it is. That's the reality.
So that
Excellent, outstanding judges
Yes.
who don't pander are kept away. And that's the problem in the system.
The underrepresentation is a big factor.
Not just underrepresentation, lack of quote unquote ultimate interest in ensuring that the institution has the confidence of the people. Ultimately, that's what's important.
Yes.
The individuals are not important.
Yes.
It's the people who are litigants that are important. They are the heart of the system, no? They are the ones who are crying for justice. So that has to be kept in mind in any process of appointment. Who is the best man for the job? Not who is my best friend.
Thank you, sir.
Good afternoon, sir. My name is Anirudh. I'm an advocate of Sikkim Bar. I have a question. Since you talked about Indra Sahani's case, how the 50% cap has not been followed. So, what are your humble suggestions on how the reservation
See, look, the problem is the following, and I have a very interesting take to this. The fact of the matter is that the agitation for reservation is firmly entrenched in our political system. Okay? You shouldn't get rid of it. You can't get rid of it. The space for reservation is limited. So people jockey being part of the reservation policy, and we have to accept that fact, and we should not shy away from it. Reservation is a political and social necessity. Okay, now that apart, that's one issue. The other issue is, how do you deal with the problem? And this is where the country and the political class does not deal with the problem. As education, if I were to be made education minister again, like I said 25% of those who are underprivileged, marginalized, should get admission into schools, right? So it gave, the top schools in Delhi, the top schools in the country have to admit 25% young people from, children of Jhuggi, children of people living in Jhuggi Jhopris, they have, and they are doing fabulously well. So basically, education is a platform on the basis of which we can deal with the question of reservation in the long term. If I were the education minister again, I would say, I will have schools for scheduled castes and scheduled tribes throughout the country, only for children of scheduled castes and scheduled tribes. I'll have schools only for the girl child. I'll have schools only for the marginalized. Because that's where empowerment is required. Right? And according to me, that will not fall foul of Article 14. Because there is a rational differential between those who are left out of the system and those who are part of the system. Now, over the long term, if you do this, then you empower those people. They will themselves say, we don't need reservation. Right? So you have to follow a two-pronged strategy. One, continue with reservation. Two, ensure empowerment. But you need to change your policy structures for that. That's my answer.
Another question is that education is there, reservations for education is there, but what about jobs? Reservation in jobs?
Reservation in jobs where? There already is. There's already in government organizations, there's reservation in jobs. The reservation policy is followed in government.
Yes, sir.
That is already available. There's a roster system and judges know about it.
How the reservation is supposed to come to an end? with the first generation taking all the benefits of
So
reservation.
now even in the sub-classification judgment, which I argued, right, for sub-classification, the judges have said that even in sub-classifications, the creamy layer has to be left out. So you have a fourth question now?
That is all, sir. Thank you.
Hello, good afternoon, sir. My name is Anjali Shah, and I would like to tell you that I am a spiritual person as a person, but I think the most important thing about the system, how it's working, yeah, anything about in your life, how you work, it's all about your mechanism, your mind, how it's work. So if we practice as whole, as a society, to manage how our mind works, even we don't have to seek what is right and what is wrong. It's the most important thing. I even cannot say that I am wrong and I am right. Then it is all my mechanism fault. Don't you think so? Would you like to express on these things?
Your conscience will tell you what's right or wrong, except that we go to temples in the evening and we rob people in the morning.
Thank you so much, sir.
Sir, I am quite familiar with you. I met you at Supreme Court twice. Today I am privileged to ask some question here.
Sure.
I am lucky. Sir, equality before law is concerned. Equality
Equality.
under Article 14 of the Indian Constitution.
Yeah.
As per my long experience as advocate and socialist, I have some doubt. Can there be equality exist in the society?
Right.
Take for example, two persons, one very rich and one poor person, have a litigation and approaching some at Supreme Court.
Don't start, don't be giving me a personal example.
Sir. I am as a rich person can afford to hire an advocate of high standing, and other persons of a economically but poor person cannot afford to hire an advocate of high standing. As per my experience as a lawyer, and I went to Supreme Court several times, persons having an economically sound person who can able to hire a good lawyer, the case is in his favor, sir. And the person who cannot able to afford a good level advocate will fail. So that, as per my opinion, there should be some support to economically unsound person for contesting such kinds of litigation.
Yeah, the problem,
Thank you so much, sir.
Yeah, the
Thank
problem with your question is that government can't be funding private litigants. Government can't be funding private litigants. How can the government allocate money for a private litigant because he is poor, therefore we'll give you money to fight? You have, of course, your programs by which micas are appointed for the purposes of arguing for those who cannot represent themselves in court. But really the solution lies in lawyers themselves doing part of their work pro bono. By and large, 40% to 50% of what I do is pro bono.
Thank you so much.
It's really the conscience of the lawyer, right? The system cannot, see, look, there is no such concept of equality. The only concept in 14 is equality of opportunity. The concept of equality doesn't exist because no man is born equal to the other, both in terms of standing, in terms of intellectual ability, in the terms of physical prowess. No one person, because each person's DNA is different. So we are essentially different. You take the animal world. right? You will find some rhinoceros who's brave and confront a lion, right? And some lion who gets afraid even by an eagle. You go to, I love watching, the animal world. You will find many such instances, right? So there are lions who are brave and there are lions who are not so brave, right? There are individuals who have, the concept of equality per se doesn't exist. But what we are talking about is equality of opportunity. And the example you are given is an equality of opportunity, that the poor man doesn't have the opportunity to have equal doesn't have the opportunity. Wait. 1 minute. The example you are giving is an example of lack of equality of opportunity. That I don't have the opportunity to have my case being represented by a man who is equally proficient in the law, right, as the person on the other side who has been appointed by a rich industrialist. That's a matter of equality of opportunity, not conceptually equality, because there is no such thing.
Thank you, sir. Thank you, sir.
Hello, sir.
Yes.
So my name is Ashian Angal. I'm an advocate. So on your second lecture, you spoke about law gives no space for judicial precedents. So on that note, I had a very specific legal question. So my question was, Section 20A, so as you know, Specific Reliefs Act, prohibits granting injunction against works done by the government relating to public infrastructure. Now, sir, my question is, so what if the land where the government is constructing that infrastructure upon belongs to a private individual? So on that note, sir, what recourse would there be available for that individual?
Where you can't get specific relief, you can ask for damages.
So, but that would
That's
that
the
mean?
law. That's the law.
So would
When,
that
for
mean?
example, you have a piece of land, a road is to be built. He doesn't want the road to go through his piece of land. Public interest will overtake it. How will you say, no, my particular piece of land, the road should not go through it, that's your private interest. So therefore, there's a salutary principle behind it. So you can't get specific performance, right? But this is in relation to contracts by and large, not otherwise. So you can ask for damages. So I think there are judgments in courts which balance all that. I don't think there should be too much of a problem with that.
So does that mean, sir, that my only recourse would be to claim damages, even though
In contractual matters. In contractual matters.
Yes, sir, in contractual matter.
Yes.
Sir, so would it not matter that my private property is now being taken without the due procedure of law
In which case you should have no land acquisition, if your argument is right.
by the government agency?
Yeah, there should be no land acquisition, so there will be no public projects. Surely you don't want that. Okay?
Thank you, sir.
Thank you.
It was a privilege.
Good afternoon, sir. I'm Sogyaltab Norbu from ICFA University, and I'm a law student, sir. First of all, it's a huge honor being able to ask questions to you, sir. Like, I've been always looking up to such a great lawyer, sir. So my question is, sir, recently you hailed the Supreme Court's ruling in the constitutional validity of Section 6A of the Citizenship Act, sir. So 6A mostly confers citizenship to immigrants who entered into Assam after January 1st, 1966 and before March 25th, sir. So mostly my question here is, sir, does that not give rights to immigrants who have come after 1971, especially after what's happening in Bangladesh right now, after the crisis happening in Bangladesh right now? So does that not give us, the Indians and India, a right to give them citizenship so they can hail citizenship into India, sir?
So first of all, this is not a legal question, it's a political question. Right? You want me to answer it? Now politically, the government has to decide its policy. At the moment, the government's policy is not to allow them entry. And you must have gone to social media platforms and you are saying that people on the other side of the border are saying allow us to enter. and the security personnel are saying, no, no, we won't allow you to enter. So that's the government policy. Should that government policy change? I don't know. That's something that Parliament has to decide. Should I want that to change? I'm not too sure, because I don't know what the problems are. Right? And as far as the 6A is concerned, the issue that I am worried about, supposing somebody says that, okay, you are not a citizen, okay, you're not entitled to the protection, let's assume. But in the meantime, he's had 4 children, right? So what's the point of sending that man across the border? What do you do with the children? They were born in India, no? They are citizens of India. So will your policy disrupt families like that? So these are very vexed, very difficult questions to answer, right? And therefore, it requires political parties to think beyond politics. Actually, most of our political parties are thinking not beyond politics. Everything is political, but there is something beyond politics called the national interest, which is also a very difficult term to define. Right? But I think we should think in terms of our future generations, and not think in terms of our future ability to aggrandize power, which seems to be the leitmotif of political parties today.
Last question now.
Yes, sir. Yes, please.
So what are your views? What are your personal views on the incumbent CJI's recent revelations that it was
No.
God?
No.
You don't want to go into it?
Look, it's like this. One, I'm the president of the bar today, right? I don't think I should have any personal views on the individual. Right? I will have a view on the institution, right? And I have elaborately discussed that view of the institution before you today. Beyond that, it is not fair for me to make any comment. Okay? I'm glad that's the last question.
My colleagues on the bench, Justice Rai, Justice Pradhan, former judges of this High Court, Justice Sabha, Justice Wangdi, Major General Kathiar, Director General of Police, all of you who are present in the audience, each one of you. Loss of one institution has been the gain of the other. The little that I researched on our resource person, Shri Kapil Sibal, is that he successfully cleared his civil services, but he volunteered not to join the administrative service. And the loser was the civil service institution, and the gainer was the judicial system of the country. So with these words, I welcome him. What did I understand from today's deliberations would be a food for thought and contemplation. But most importantly, what Mr. Kapil Sibal has succinctly told us, and it has mostly remained unsaid, you raise your words but not your voice. I am quoting from poet Rumi. You can actually use your wisdom expressed through words than shouting at the top of your voice in order to drive home a point. He could do it succinctly, subtly, without raising the voice. He was one of the epitomes of that kind of, orator. Traditionally, ever since the concept of bar and bench evolved around the judicial system, they complemented each other like two sides of the same coin. And this was the very expression that I was having when I was having a cup of tea with Mr. Sibal. It is this symbiosis which prompted me to request Shri Sibal, learned senior advocate of the Supreme Court of India, to come to Gangtok as a resource person for the Sikkim Judicial Academy. Here, I must hasten to add, not every son or daughter of a legend becomes as illustrious as his or her parents. His father, the late Hiralal Sibal, who was a renowned lawyer, as I've been able to do a little research, was named or labeled as a living legend of the law by International Bar Association sometime in the year 1994. He was the father, and Shri Sibal is his worthy son. It has not been highlighted by the presenter of today's program. Our resource person has been conferred with the national honor and title of Padma Bhushan. The presentation of Shri Sibal before this very receptive audience and those who are watching or hearing in the live streaming that we have provided and also in the YouTube channel. And I'm sure his words, whatever he has spoken to, as I said at the early stage of my speech, will provide us with food for thought and great contemplation, because the time has come in this country to contemplate in which direction we would like to take the judicial system further for the betterment of the society. With these words, thank you very much, and thank you, Mr. Sibal, from the bottom of my heart.